esteemed colleagues, dear colleagues, dear, may I say, friends, I started to feel familiar here with this place, and I'm really privileged, truly privileged and honored to participate in this conference. And I would like to convey my appreciation to organizers for having me here today, and as well to congratulate you, since this is the second day, so I can congratulate you for the perfect, excellent organization of this event. All speakers that were before me, they said that they will follow the time frame. Since I'm coming from the Balkans, and we are very well known of being adherence of our adherence to the rules and regulations, so it is not necessary to emphasize that I will also respect the time frame. Let's go to the let's focus to the historical background. When it comes to the religion, there is always a little bit of history. There is a lot of history, sorry, but I will make a brief introduction on the religious freedom as it has developed through the history. So even from ancient times, you can find something like religious tolerance, especially in the empires, multi-ethnic and multi-religious empires like Roman Empire, and also in ancient Greece and so on. The international public order in the Europe was formed by two milestone treaties: the religious treaty of Augsburg in 1555 and the Treaty of Westphalia, which tried to prevent religious conflicts and religious wars in the region of Europe. After the First World War, we had so-called minority treaties. Those treaties tried to give some guarantees for religious minorities and religious rights for ethnic or national minorities, we would say, in this region. And after the World War, we come to this new stage of protecting religious freedom, the protecting of individual religious freedom. All this introduction, actually, I wrote just to come to this point of my presentation, and I would like to say a few words about Cardinal Mindszenty, Joseph Mindszenty. In 1948, our Hungarian friends probably know that better than me, he was arrested for fabricated for fabricated accusations on that he of treason, and that he organized rebellion, I think, against the communist regime and so on. And this case, this affair, Mindszenty affair, actually influenced the first resolution, UN Assembly resolution that asked from one member state to respect the religious freedom. And this affair actually influenced the religious freedom protection in future, in the years after this affair. So I felt, let's say, a moral duty to mention him here in Budapest, since we are here now discussing about religious freedom protection. So that is enough of history. It is important, of course, part of the protection of the evolution of the protection of religious freedom. Article 9, as you can see it is pretty much similar, or there is a proximity in both in textually and in values with other articles. They are, let's say, or freedoms, they are neighboring freedoms, Article 10 and Article 11. So you can see that in the first paragraph we have this description of the right that is protected, and in the second paragraph there are provisions that regulate limitations. Of course, there is one small difference. Right to freedom of thought, conscience, and religion cannot be limited. Only manifestation of religion can be limited. So whatever we believe inside of us, that is outside of the legal order. That is something that legal order cannot change, that cannot interfere with that. But when we manifest our inner beliefs or conscience or religion, then it enters the world of law, and then some limitations are sometimes necessary, sometimes not. We will discuss about it later. So the Article 2 of the Protocol number 1 also has to do with protection of religious freedom, because it provides the right to parents to provide their education according to their philosophical or religious convictions. Now, when it comes to how to define what conscience, thought, and religions are, European Court, I will give just a few examples. For example, beliefs in assisted suicide or leg-rich preferences or disposal of human remains are not beliefs protected by the Article 9, according to the jurisprudence of the court. From the other side, we have, for example, pacifism, atheism, and even veganism as ideologies or beliefs that enjoy the protection under the Article 9 of the Convention, according to the jurisprudence of the court, of course. It's ironic that even communism was protected according to Article 9 in one case. But when it is about conscience and thought, those cases usually have to do with the freedom of speech or with the freedom of assembly or association, and not so with the freedom they are not in the scope of the Article 9, but of other articles of the Convention. So I already said a few words about forum internum, or internal dimension of this right, and external dimension. There is also individual dimension. You can practice your religion in your room, and the collective dimension, that is actually something that court deals with in most cases. Of course, there is private and public dimensions. They are both guaranteed. You can remember in communism, for example, their approach was, you have the freedom to practice your religion, just close the curtains close to your room and you can do whatever you want. That is not freedom of religion. That is something else. Okay, now let's shift to some numbers. First, I would like to remember you that of the saying that there are three kinds of lies: lies, damned lies, and statistics. So here we are dealing with statistics. If you take a look on the table, on the content of this table, we see that in our region we have only one violation of the religious freedom. Of course, okay. This is an official statistics. But if I had numbers with all the applications in which the number 9 or the Article 9 was mentioned, these numbers would be changed a lot. But we can still see that, for example, even European champions, as I call them, so Russia, Greece, and Turkey, they have hundreds of cases actually. This is just for violating of the Article 9. So even in their cases, those numbers are not so big as the real situation is much different. So what could we conclude from this? First of all, is that our region is not a problematic region when it comes to religious freedom. And that is something that you should be proud of. So we are not region, and completely, I'm talking about the whole Central Europe, the region that has any more persecution, religious persecution, or some similar practices. The second conclusion is that actually we do have problems, but with the collective dimension of religious freedom, and not by individual. And we will speak about it. We will see it now. So, for example, one more characteristic of our region is that almost all countries in this region use this or implement this state-religion model of cooperation. So one exception is probably Slovenia, but all the other states have opted for this type of state-religion, state-church relations. This model actually is proper for our region because of the decades of persecution of religion, and now religion needs some help, needs some cooperation to revitalize. From the point of view of the European Court, there is a wide margin of appreciation of the states to choose the model of state-church relations. And you can see it if you compare, for example, the United Kingdom, where the king is the head of the church. Anglican Church has bishops in the House of Lords. Anglican Church is an official state church, established church in the Great Britain. And if you just cross the channel from the other side, you will be in France, a laïc state. It is a pure laïc state with a little bit even anti-clerical, rigid system of separation of church and state. And it works perfectly in our Europe, that is Europe of differences. So our states opted for this kind of state-church relations that emphasize the cooperation between state and the religion. But states do not want to cooperate with all religions in the same way. And there are many reasons that we can justify this decision. It is not possible to have the same cooperation with small and new established churches and with a traditional church that has the majority of the population. And that's the reason why we, in this region, you can see this multi-tiered system of registration. That is the way how to make different types of religious organizations. So there is the top tier. They have most benefits, tax exceptions, state funds, access to public institutions, and so on and so on. Then there is the middle tier that has some advantages, but not all of them. And then that is the bottom tier, or the last tier, that actually provides only for basic legal entity, basic legal protection, or that those are associations usually. Even though this system works in all Central European countries, Hungary was the only one to be judged for this. That is the case of Magyar Keresztény Hungarian Christian Mennonite Church against Hungary. What is the point of this judgment? I believe that court said something very important here, and that is the regulation of these relations remains under the margin of appreciation of the state. But multi-tier systems are not does not violate the Article 9 per se by itself. But in some cases it can happen. Unfortunately, all cases that come in front of the court regarding this issue, actually they find at the end they find violations. But the court states that this system per se by itself does not violate the religious freedom. I should go for this is one more characteristic of our region. Those are agreements or concordats between the state and the religion and religious organizations that you can find in all countries in the region except Orthodox countries. Even in Serbia, for example, there is agreement about that regulates the higher education of Roman Catholic Church. So I think that in all countries in the region there are some agreements, The only case that from our region that is important, that is Savez Crkva Rijeka Života and others versus Croatia. I think that this case was mentioned yesterday. The key point is that once the state signs agreement with one religious organization, it is obliged to sign the same agreement with all the other religious organizations that would like to do that. Of course, there is no mandatory agreement. And finally, something that is very topical at this moment, that's actually started from United States, those struggle against the blasphemy laws. And recently, last year, there was a case, Rabczewska, I hope that's the correct pronunciation, versus Poland. I will leave this case to be analyzed by those who deal with freedom of speech. But from the point of view of the Article 9, from the point of view of the religious freedom, there are few important moments in this case. I think that I have one, okay, just to give you a brief explanation what happened, because there are two almost similar cases, one in Austria and one in Poland. Let's call them Austria's case and Poland's case. Okay, in Austria, there was a woman, both are women actually, there was a woman who declared that we should not, adult Muslims, should not follow the example of Muhammad, because he actually was in marriage with a 6-year-old Aisha girl when he was in the age of 56. So she said this is a tendency to pedophilia. Okay. The other case that happened in Poland, a famous singer, Doda, something like that. Doda, yeah. She gave an interview for a newspaper, and she said that Holy Bible are writings of someone wasted from drinking wine and smoking some weed. When you, in both cases, there is blasphemy against both cases. Two religions were, or let's say, objects of venerations were blasphemized. But the court, European court, in the Polish case, found that there was a violation of the freedom of speech, because the court convicted this Doda, Doda, okay. And in the Austrian case, the court found that there was no violation, even okay. Okay, you were laughing when I said that I'm from Balkan, so now I can continue. Yes. But from the point of view, that is, I will leave this to be discussed by experts for the freedom of speech. There are two main points that should be emphasized from the point of view of the religious freedom protection. First one, the court insist on the factual accuracy or factual basis, and they entered into the discuss whether the Prophet Muhammad was a pedophile or not. And you can read it. You can find this. So they try to find historical proofs that he was not pedophile. Okay, and even they mentioned that it's impossible. They mentioned that even in medieval Europe, rulers had entered into marriages with children. But if you compare medieval Europe with ancient Saudi Arabia, that is really difficult to explain and to find something common in that. I wanted just to emphasize that I think the court should stay out of this kind of assessments. There is no need to assess religious doctrines or religious believings or something like that. That is not because we can face the, maybe we will see the discussion about Christ and whether he has risen or not in the future. Or one other colleague, he he wrote that he wrote that maybe the court will have to discuss about factual basis how animals in the Noah's Ark were able to effectively procreate. So I think the court should stay out of those kind of assessments and discussions. And the second problem is the protection of religious feelings, because the court so far has protected religious feelings only of Muslims. There is no case of protecting religious feelings of Christians. Maybe we do not have religious feelings, but that's other topic to discuss. Sorry for taking your time, and thank you for your attention.